Hey everyone, Harry here to talk about Donald Trump's reply brief in the Supreme Court in support of his motion for a stay of the DC Circuit opinion denying his immunity motion. Now remember, this is all about a stay litigation. This is about keeping the DC Circuit opinion from going into effect and from returning to Judge Tanya Chutkan, which would mean the end of this whole immunity frolic and detour. The DC Circuit, when it ruled, gave them until last Monday to file a motion for a stay, saying that their mandate only went till then. The motion in the Supreme Court is good enough to keep it alive, the stay, but it will go away if the court decides not to grant one. So, stay. 5 votes, not 4. And special standard, we're not talking about a decision on the merits and whether it's cert worthy to consider whether there should be immunity, at least ostensibly under the law, we're not. We're talking about the special heightened standard for a stay, which is whether Trump can prove, most importantly, a good prospect of reversal. That is a good prospect that the Supreme Court will reverse the DC Circuit on immunity, and also that the balance of equities favors him. And you know that's a sort of case specific idea. But you know it is right now. So he files it on Monday. On Tuesday, they tell the Smith, you've got a week, and that's really quick. File your response in a week. Smith said, I don't need a week. Let's get it on. And in this swashbuckling fashion, he filed it a day later. So really, on the one hand, you know, showing a kind of flair, but also really showing the need for speed. And that's his theme here. And now Trump filed yesterday. The justices will have a conference today in the afternoon. It's all in front of them. It is possible. There's, you know, handicappers and handicapping what the justices will do in their conference, which is sacrosanct, behind closed doors. No one knows anything. Really, it's a whole sort of ritual. Literally, no one's there but the justices. If there's, you know, an attack on the White House, somebody knocks on the door and the junior justice goes to the door and gets the piece of paper. So Justice Barrett, you know, well, guys, you know, but they're never in there. It's really full of lore. Nobody else but the justices. Anyway, they have in front of them. They could, in fact, today decide whether to grant the stay. Here are the two major decisions in front of them. Let me make this the second main point. They can deny the stay. I'll get back to that in a second. Or they can decide to hear the case. Now, notice I didn't say grant the stay, but that's because granting the stay would be tantamount to hearing the case. Indeed, what Smith said in his brief to them is deny the stay, but if you're not going to do that, treat the stay application by Trump as a motion for cert, a motion for review. Grant the review and give it very expedited treatment, very short deadlines, etc., like you do in these occasional cases needing real expedited review. So it sounds a little weird. Just take this motion for stay and call it a motion for cert, but they've done it, and he's saying do it again. And that would probably equate to hearing the case in maybe late March, maybe a decision in a month, but could be dissents, etc. Well, let's go back to the stay, because here's the thing: the stay not only requires 5 votes rather than 4. It's got its own standard, and one of them is this fair prospect of reversal. And kind of everybody, certainly me, thinks that the Supreme Court's not going to reverse the DC Circuit. They're going to agree with the DC Circuit. Now, they might take the case and agree, But if they were really, deciding this down the line according to the law, and certainly they can do this in a way that it wouldn't be, that would be impeccable, they would say there's not a fair degree of prospect of reversal here. And that would be the end of it. They could still, if they wanted, take up the case for review, wait for a petition for cert, grant it, hear it, decide against him, probably by a lopsided, if not unanimous vote. Always remember Alito and Thomas bringing up the right. But that would be a different thing. That's about reviewing the case on the merits. This is about granting a stay. And, I think an honest broker's application of this all-important factor, prospects of reversal, would say that there's not good prospects, and that should grant that. For that, you should have a stay for that alone. All right, that's the one big issue in play on the standard for granting a stay. The other one is the balance of the equities, and this is interesting. Throughout the case and other cases, Jack Smith has stated how it's important to have expeditious treatment, speed, etc. But it's because of, the criminal law requires it, a sort of general statement. What he hasn't said, what he has studiously avoided saying is, we really should get a trial by November so the public can know the results when they go to the polls. And the main reason he's done that is DOJ policy is, and we're not talking about the policy which people broadly misunderstand, of not taking an overt investigative step 60 days before an election. There's a separate policy that says you can't take any action based on any action. You can't, choose your pen based on the prospect that it would advantage or disadvantage a particular political candidate, period. Now, that's a nuanced question here, right? In a sense, it disadvantages Trump to go to trial before the election. In a sense, it's not about Trump. It's about the American people. It gives them more information, etc. And in his response, Smith tiptoed up to the line closer than he has before of saying, the balance of equities favors fast treatment, especially here, he says, where a president has been accused of a crime, etc. Doesn't quite pull the trigger on saying, because we need this, by November. All right. So now Trump's reply brief starts there and just lambasts him and says, Smith, this is all, he's now shown his true colors. It's just an election interference conspiracy. It's just, trying to keep me from winning and I've got all the lead in the polls. This is the first 5 pages of a brief to the Supreme Court. Hard for me to overemphasize how inappropriate it is. It's political screed, not written for the justices. They would look at it and be alienated, irritated. Maybe they would just ignore it. They're political actors as well, but it gets him nowhere. All right. And then and only then he gets into, I got a good chance of winning on of you guys reversing, but he trots out the same arguments about, Marbury versus Madison and the impeachment clause and, arguments that the DC Circuit really shredded and don't have much purchase at all. I do not think they would persuade the justices. So the focus on that really is, if they really are talking about prospects of reversal, they should go against them. Now, I don't mean to criticize. It's a very big case. I've said before, it's inevitable and maybe not inappropriate that they'll be thinking in grander political terms or thinking about institutional standing of the Supreme Court. But notwithstanding the very strong case just on the straight up law that you don't get to stay here because you're not likely to win, it's kind of a bigger deal than that. And, I'm unafraid of in a 60-40 situation of saying, my prediction is X. And indeed, even on this one, I said on national TV, if you put a gun to my head, I would predict no stay, that they'll deny, and happy days are here again. But it is, the more you think about it, the more I think about it, it is really a down the middle, even money proposition. If you want to keep it in gambling terms, you could really see they're saying, why do we need this? DC Circuit got it right. We're going to be responsible for a couple months delay. That might be responsible for either the case not happening or happening in the middle of a campaign season, a total mess. We've already taken up the Colorado case. We've taken on that water. Why this? Plus, he's not going to win on appeal, and so no stay. And you can see them saying, we're the Supreme Court, DC Circuit. It's good opinion, but we're the Supreme Court, and we're the ones who, for the country's sake and for the sake of the Supreme Court, which we are, they need to go forward, and it's their job to decide the case. And that's going to be, it might be a personal decision and predilection of individual justices. But I think it's those sorts of who am I as a justice? Who are we as a court that will drive things? And, notwithstanding Smith's arguments about, for Trump, I don't think they'll have much of an impact here. The court knows about the case, knows about the stakes, and will decide on its own, basically. It's bigger than the arguments of the advocates, is one way to put it. Okay, so if it could be, we could know literally as early as today. They're now, when they make decisions in conference on Friday, you find out the next Monday, but not invariably if they're thinking about speed. Could just boom, let's just rip the Band-Aid off. If they don't do it in conference this week, the next conference is a week from today, and then it would be likely, quite likely, I think, if they haven't done it already, that they do it then, and then you have the same dynamic. Would it be in the afternoon or Monday morning? Okay, so there you have it. High drama in the Supreme Court, kind of either way, and with at least the 49% prospect, or 50.1, I guess I would say, that they'll say no stay, and that'll be it. Back to Judge Chutkan's courtroom with that case again, maybe immediately after the New York DA case, the Bragg case that we just got a date of March 25th for. But, looking as if it's going forward under the stewardship and even whip hand of Judge Tanya Chutkan. Big news. It's the most important case out there, and whether or not it's tried in 2024 hangs in the balance. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.